Expert joins me from our Pretoria studio. Thanks so much for your time on Point this afternoon. Just take us through what exactly voluntary business rescue is and what does it mean for the national carrier?
Thank you so much for having me this afternoon, Zinga. So business rescue is essentially a process that has been developed through Chapter 6 of the 2008 Act to provide companies that are financially distressed with a sort of environment that allows them to strive to rescue that company. So a rescue within the context of Chapter 6 entails one of two objectives. The first objective is to either return the company to a state of solvency in the event that the distress that the company was facing was a solvency-based distress, or to return that company to a state of liquidity. And if that option is not available or is not possible, then it is to achieve a better return for the creditors than would eventuate if the company were to be immediately liquidated.
So what's the exact process that will be followed from now when it comes to SAA?
Okay, so in order to first get into business rescue, it must be determined that the company is financially distressed. And so the financial distress test is a test that is forward-looking in the sense that the board has to ask itself, if within the immediately ensuing 6 months there is a reasonable possibility that the company is going to be insolvent, or if within the immediately ensuing 6 months the company is going to be liquid, then that company is financially distressed within the meaning of Chapter 6. Then the board must then ask itself if there are reasonable prospects of rescuing that company. And if the board answers that question in the affirmative, then the board can place that company into business rescue by passing a resolution. So once the resolution is passed, the resolution must be filed with CIPC along with the supporting documents that include a sworn statement by a director of the company stipulating the financial situation that the company finds itself in. Once that is filed, then within 5 days from that, the board must then notify the affected parties of the fact that such a resolution has been passed and filed with the CIPC, and it must also appoint a business rescue practitioner. But what's important to note, though, is that as soon as the resolution is filed with CIPC, the company in question is officially in business rescue.
So we are hearing that that resolution has been filed with the CIPC. So who is in charge of the airline as we speak then?
So the airline will be taken over by the business rescue practitioner once that business rescue practitioner is appointed. And what's important to note also with regards to this appointment is that the business rescue practitioner then steps into the shoes of the management of the company, as well as the board of the company, and then takes over the affairs from there on.
So could you explain to us, if the business rescue practitioner is stepping into those shoes, what role does government have in the running of SAA going forward?
The business rescue is the one with the sole responsibility for running the company. So the government does not have any role beyond the rights that are given to shareholders as affected parties to participate in the business rescue process. But the business rescue practitioner is enjoined by the Act to be independent and to carry out its affairs without having any regard for favor with regards to any particular creditor or any particular affected party.
Okay, there has been panic, Muzi, since this news come out from SAA customers about whether or not their tickets will be valid and how the operations of SAA will work going forward. Tell us about that.
So what the practitioner is supposed to do once they're appointed is that they're supposed to conduct an inquiry into the affairs of the business. So this inquiry will involve all the operations that the business is involved in, and from there on they're supposed to hold a creditors meeting where they're supposed to inform the creditors and other affected parties of the contents of the report, as well as to give an opinion as to whether or not the entity is capable of a rescue in terms of the provisions of the Act.
Mm-hmm. When we've been speaking about state-owned enterprises like SAA, like Eskom, there's a fear from some quarters about privatisation and what would that mean for competition as well as prizes. What would you say is going to be the effect perhaps in a year or more of this business rescue?
The interesting thing about this business rescue is that we are chartering into the unknown in a lot of respects, particularly because even though business rescue has been ongoing for the better part of 5 years, it's the first time that we're dealing with a business rescue where an SOE is involved. And it's the first time we're dealing with, I think it's probably the biggest business rescue that we've dealt with in the country so far. But what I can say is that the Act does have sufficient safeguards for employees, it does have sufficient safeguards for creditors, and the business rescue practitioner, as mentioned, is supposed to embark on this process in a very balanced manner rather. And if there is going to be a disposal of any assets, this disposal is not going to be done behind closed doors. It's going to have to take place through a business rescue plan, or is going to have to take place through consultation with affected parties. And because government is also a major creditor of SAA as well, they will be informed of the processes as they take place.
Muzi Zwane, business rescue practitioner, joining me from our Pretoria studios. Thanks so much for your time on Point this